Hi friends, let us understand the TDS concept under the Income Tax Act and what are the consequences of the TDS deducted but not deposited to the account of the central government or deposited but with delay. And both situations definitely result some consequence. It is a very great importance as the tax collection through the provisions of the TDS accounts nearly 30 to 40% of the collection of the central government of total direct taxes. So it is a very great importance. Second, it facilitates the continuous flow of funds to the central government, and as well it also lessens the burden of on the income taxpayer. So in this case, the persons who failed to deposit the tax deducted, collected to the credit of the central government within the due date, then in this case, if it is not done, then shall be liable for the rigorous imprisonment. So rigorous consequences, in this case, the consequence will be monetary or non-monetary. If it counts the monetary, and in this case, the monetary will be the interest and the penalties. Non-monetary will be the prosecutions. So the section that deals with the prosecution, that's a section 276B of the income tax. The bare saying here is that the failure to pay the tax to the credit of the central government under Chapter XII-D or the Chapter XVII-B. So, if a person fail to pay to the credit of the central government, shall be punishable with a rigorous imprisonment, which will be not less than 3 months and which may extend to 7 years along with the fine. Now, the fails to pay cannot be confined to the total failure, it may be a partial failure. And second, in this case, for example, some amount has been deducted, so a part payment has been deposited to the credit of the central government and a partly has not been deposited or has been deposited with a delay. Now the prosecution can not only launched for only not deposited, can also be launched with the deposited with the delay mode. So even it has been deposited with the delay, it also may attract the prosecutions. Now it has been decided in case of Rayala Corporations versus Income Tax Official. So late deposit will not absolve the accused. In this case, a mens rea is not compulsory to prove for prosecution. So mens rea is not compulsory, it's not mandatory to prove for prosecutions under section 276B of the Income Tax Act. Now, what will protect you and you have to counter, that is a reasonable cause. So a reasonable cause is required to avoid the prosecution. So what you have to focus, that's you have to prove the reasonable cause. That is the only thing that may protect and avoid the prosecutions. Now section 278 AA of the Income Tax Act 1961. No person shall be punishable for any failure referred to section 276B of the Income Tax Act if he or she able to prove that there was a reasonable cause for such failure, and able to prove the reasonable cause for such failure, then can't be prosecuted as per section 278 AA of Income Tax Act. Now section 279 of the Income Tax Act, for the sanction to be granted for such prosecution by the Chief Commissioner, who is required to apply his mind considering all the required documents and the informations while deciding, while arriving at the decision to whether to initiate or not to initiate prosecution under each case. So the grant of sanction of launching prosecution is a very serious and extreme prosecution measure which entails proper exercise and of the discretion upon the consideration of the all relevant documents on each and every cases. Now with the circular that had been issued, circular number 24 oblique 2019 dated 9th September 2019, and CBDT has laid down a new criteria to ensure only the deserving cases get prosecuted. And in this case, no prosecution can be processed in the normal circumstances where the tax are not deported. The tax issue is less than 25 lakh rupees, or the delay which is less than 60 days. Then will not be taken for the prosecutions. Now, what will happen if there is a situations where there is a habitual offender? So, in case of habitual offender, based on the particular facts and the circumstances of the each case, prosecution may be initiated only with the previous administrative approval of the Collegium of the two Chief Commissioner of Income Tax or the Director General of Income Tax. And in this case, if it is get the sanction and the approval, then for the habitual offenders can be prosecuted. Now, the in case of the habitual offenders, there has been not any uh, criteria limit has been prescribed that that is in case of normal circumstances. For example, it's not a habitual offender and the deduct tax disputed amount is less than 25 lakh, or the delay is less than 60 days. So in this case, but the tax amount has been criteria or the lead has been mentioned delay. Now for habitual offenders, no such amount has been prescribed, or the number of the delay has been prescribed. So for even if it is a small delay, even if it is a small amount, and if it is a repeated offenders, so with a with a prior permissions of the Collegium of two chief. Commissioner of Income Tax or the Director General of Income Tax, the person may be prosecuted. Now, few things we have to keep in mind. If you are facing a tedious litigation path, now if it has been delayed to deposit to the credit of the central government, or has not been deposited due to any reasons. Now, in this case, if you are giving, or if you have the argument that uh, you had not any bad intentions, so mens rea, as has been mentioned in this tedious provisions, that it's not necessary to prove the mens rea to get the prosecutions. So you don't have to focus on the part mens rea, that's a bad intentions or criminal intent. So that was not intentional. Now what you have to counter and what you have to present your argument, what you have to fight, that's a reasonable cause. So what was the reasonable cause that has prevented you to not the deposited amount to the credit of the central government, or has been deposited but with a delay? So you have to explain the circumstances with the justifications, with a reasonable cause, and it has been proved. Then in these situations, if it is has been proved, then prosecution may not be initiated. So now you have to keep in mind the section 278 AA of Income Tax Act, that the as has been section 276B of the income tax, where the prosecution under this may be prosecuted, but as per section 278A, where there is a reasonable cause and able to prove the reasonable cause for such failure, the person can't be prosecuted, which has been mentioned under section 276 of B. So, if you are facing such TDS related dispute, TDS related litigations, depending upon the case to case, so for each and every case, there will have a separate study and separate argument and separate planning for counter and present your case if you are facing the TDS related litigations. So, to get more information related to TDS litigations, please subscribe our channel. Thank you.